Welcome everyone to this video. In this video we will discuss about the 10th schedule. We have seen this in the news a lot of times about the disqualification of members of parliament or state legislature. So let's look at this. What is it? 10th schedule was added in 52nd Amendment Act. Which act? 52nd Amendment Act in the year 1985. What is it is provided? It's provided for the disqualification. The 57th Amendment provided for disqualification of members of parliament as well as the state legislature on the ground of what? Defection from one political party to another political party. So what is the defection? Defection means is defined as either voluntarily giving up membership of his party or disobeying or abstaining voting against the directive of the political whip of a party leadership on a vote in legislature. So this is what it is called defection. So what is defection? Defection is defined as either voluntarily giving up membership of his party or disobeying, abstaining or voting against the directive of political whip of the party. So what is the provision of the act? The 10th schedule contains the following provisions. So let us see what are the provisions it has. First is disqualification. When we can say that member is disqualified. Member of political parties, a member of a house belonging to any political party, we call it a member of a political party. Become disqualified. A member of a political party, say BJP or Congress, disqualified. Why? When he voluntarily gives up his, voluntarily says, no, I don't want to be a part of Congress or BJP anymore. So his membership, so he becomes disqualified because you have own a seat from a political party. When you say that I don't like this party, I'll resign. So he automatically disqualifies. Another is if the member, whether a parliament or state legislature, abstains or absent from voting in such house, contrary, that is opposing. If party is saying vote in favor of this bill, but the member says no, I will not vote, he becomes disqualified. To any direction issued by his political party without obtaining prior permission of such party, such an act has been condoned except a behavior that is considered morally wrong or offensive by the party within the 15 days. So how one get disqualified? When he voluntarily gives us the membership or if he abstains from voting in the house contrary to opposing to direction issued by his political party. He is not voting in favor of the party, he becomes disqualified. But if the party condemns him within 15 days, he remains a member of the party. Means he is not disqualified. So from the above, what can we say? It is clear. It is clear that what? It is clear that member elected on a party ticket should continue to be in the party and obey the party direction. So if you are elected to any of the house, whether parliament or state legislature, you must follow the direction of the party if you want to continue to be a member of the house. What happens to independent member? So there are many members you see that get elected in the house by the state party or whether in the state legislative assembly or in the parliament. An independent member of a house elected without being set up as a candidate by any political party become disqualified to remain a member of the house if he joins any political party. So suppose a member wins a seat as an independent member, but after result of the election he joins any political party, he automatically disqualifies to be a member of the house. What happens to the nominated members? Another option is we see a lot of nominated members in the parliament. A nominated member of a house becomes disqualified on being a member of the house if he joins any political party after the expiry of 6 months. So nominated member within 6 months of his nomination can join a political party, but after 6 months he cannot join a political party. If he joins, he disqualifies. So in short, that this means what? He may join any political party within 6 months, taking his seat in the house without inviting disqualification. So within 6 months he can join. Nominated members within 6 months of nomination, he can join any political party, but after expiration of 6 months after joining a party as a nominated member, he cannot join a party. If he joins, he disqualifies. There are few exceptions, so let's say what are the exceptions. The above disqualification on the ground of defection does not apply. Following two cases: when if a member goes out of a party as a result of merger. Suppose there are two political parties, a political party A and political party B. If these two party merger, if these two parties say that will merger and become a single party, then the member does not qualify. Member does not disqualify. But this merger takes place only when 2/3 of the member, let's say 66% people says yes, 66% members of party A says will join party B and form a government or whatever they want to do. But if 2/3 of a member of a party joins a party B, that does not disqualify. So this is the exceptional case in the defection. If a member, after being elected as a presiding officer, we know presiding officer, Speaker of the Lok Sabha, these are called presiding officer, Speaker of the Lok Sabha, Speaker in the state legislative assemblies. So once someone becomes Speaker, he automatically give up his party membership, but he does not disqualify as a part of defection. So these are the two exceptions. What are the two exceptions? One is the merger. If political party A merges with political party B, the member does not disqualify. And if a member becomes presiding officer, maybe Speaker of the Lok Sabha, Speaker of the State Legislative Assembly, he does not disqualify to be a member of the House. So why this exemption added? The Speaker just dignity, for the dignity and impartial to the office. Speaker, once a member becomes Speaker of the House, he does not disqualify because dignity and impartial to the office, because a Speaker has to be impartial. And it is a dignity to be a Speaker of a House, so he does not disqualify. It must be noted here that provision of 10th schedule, exemption of disqualification, split. One is split, another is merger. What happens is split. In the split, if 1/3, like 33% member says, okay, we'll split from our original party and we will do whatever we want. There was a provision, but it was deleted in the 91st Amendment Act. So currently only merger is applicable, split is not. In case of merger, 66% or 2/3 member must say, yes, party A must say that we will join party B. And in the split, 33% or 1/3 member says, okay, we will not remain member of party A. So there is previously this provision was there. Split was also exempted from defection, but currently it is not, because 91st Amendment Act 2003, the split option was removed. It means that defectors have no more protection on the grounds of split. Currently only defection are protected on the grounds of merger, but not in the grounds of split. In the split, like 1/3 member, and in the merger, we have 2/3 of the members. Now, who is the deciding authority? Who decides that a member will remain in the House or not? Any question regarding the disqualification, who will decide? Regarding the disqualification arising out of the defection is decided by presiding officer, that is Speaker of the House. Originally, Act provided that decision of the presiding officer is final. Previously, it was held that the decision of the presiding officer or Speaker of the House is final in matter of defection. But in Quixote Holohan cases in 1993 said that the Supreme Court declared that provision is unconstitutional, because you are undermining the authority of the law. So it says that final decision regarding the disqualification, who is the final authority? If somebody wants to appeal, it is the Supreme Court will decide. On the grounds that it seeks to take away the jurisdiction. Previously it was held that Speaker is the final authority. Now Supreme Court says it is taking away the authority, it is taking away the authority of the jurisdiction of the Supreme Court and the High Court. It held that presiding officer while deciding the question under the 10th schedule function as a tribunal. Tribunal is what? Tribunal 1 that follows natural law of justice. Hence the decision like any other tribunal. So decision of the Speaker of the House is like any other tribunal. It is subject to judicial review because Speaker may be wrong. So it is decided by the judiciary, that is Supreme Court or High Court, on the grounds of malefides, perversity, etc. So the court rejected the contention. That vesting of adjudicatory powers in the presiding officer itself invalid. So final decision is not the decision of the Speaker. It will be decided by either High Court or the Supreme Court. Rule making power. So who will making the rule in the House? The presiding officer or the Speaker of the House will make the rules regarding the conduct of the members. Presiding officer of the House is empowered to make rules to give effect to the provision of 10th schedule. All such rule must be placed before the House for 30 days. If he is making any rule regarding the conduct of the members of the House, it should be placed before the House for 30 days to decide whether it is approved or not approved. House may approve it or modify it or disapprove it. Further, he may direct that willful contravention, that is violation of any member of such rules, may dealt in the manner the breach of privilege of the House according to rules are made. So presiding officer can take up a defection case only when he receives a complaint from the member of the House. So when the presiding officer will take a case, any member of the House decide that this XYZ member is violating the rules of the law, he must be denied of his membership because he is violating the privilege of the House. Violation of privilege of the House is this, violating the rule of the House. Before taking the final decision, he must give members against whom complaint has been made. He must give the member a chance to submit his explanation. If somebody is complaining that XYZ member is violating the rule of the House, the member, the question will be given a chance to explain why he is conducting like this or against the rule of the law or against the rule of the House. Hence defection has no immediate automatic effect. If somebody complaining XYZ is not following the rule, it is not automatic. Speaker will give him an option to explain why he is behaving like this, why he is violating the rules or said norms of the House. So it is not automatic effect. He must be given a chance to explain his act, evaluation of the act. 10th schedule of the Constitution. So we know the 10th schedule. The 10th schedule of the Constitution, which embodies the anti-defection law. 10th schedule is called anti-defection law. Defection means doing anti-party activity or resigning from the party or violating the rule of the party. It is designed to prevent the evil of mischief of political defection. Why we have 10th schedule? To prevent the evil of mischief. What happens in the mischief? Suppose there are two parties. One party has 99 members, other party has 101 member. But this party with 99 member may try to buy some MLS of this party, say 2 members. And if these 2 members goes to this party, members with 99 members, they will attain majority. So avoid such kind of contradictions or mischief. We have this defection law. Defection is motivated by the lure of office, material benefits. Suppose party with 99 MLS come to our party, will give you 15 crore, 20 crore, 50 crore, whatever it is. Other similar consideration. It is intended to strengthen the fabric of Indian parliamentary democracy so that no horse trading take place. We have anti-defection law. By curbing the unprincipled, unethical political defections, this is the actual, we have what? So that we can prevent unprincipled, unethical political defection. But really, does it happen? It does not. You will see a lot of states are doing the same thing, buying MLS of another party and breaking the government and making the government. This is what happens in India. Politicians rarely follow any ethical principles. This is what said Rajiv Gandhi after passing this 10th schedule. Then Prime Minister described the first step towards cleaning up the public life. This anti-defection law, or the 10th schedule, was brought for cleaning up the public life so that MLAs behave ethically, but really, does they? I don't think. Then Central Minister of the Law stated that passing this 52nd Amendment Bill or Anti-57 Amendment Bill or Anti-Defection Bill, this bill is called 52nd Amendment Bill or Anti-Defection Bill, or passed in 1985 by an unanimous vote by both the House of the Parliament as a proof that any maturity of Indian democracy. So this bill shows that Indian democracy is really maturing. Really, we need to see it. So what are the advantages? What are the advantages of this anti-defection law? It provides a greater stability. How it provides stability? Like members of one party cannot go to another party. Like say party MLS of party A cannot resign from party and join party B, because if he resigns from a party, he becomes disqualified. So again he need to fight the election. In the body politic, by clicking up propensity, legislature change the parties. It facilitates democratic realignment of the parties, legislature by way of merger of parties, and it provides democratic realignment. Like we have seen, merger is allowed, split is not allowed. In the merger, if 2/3 of the members of a party A says will join party B, they remain a member. So merger is allowed. It reduces the corruption in the political level as well as developmental expenditure. What happens if we allow defections, like a member of party A going to party B by taking some money from the party B? It will create instability in Indian politics or in the house. So government will fall and rise with the power of money. So this anti-defection law, we have actually brought little bit of stability, but not full stability. We have seen what happens in Madhya Pradesh, we have seen what happened in Karnataka, and we may see what is happening in Rajasthan shortly. It gives us the first time that clear-cut constitutional recognition of existence of political party. So these are not important points. So what is the criticism? The criticism is that though anti-defection law has been hailed as a bold step towards cleansing our political life, started as a new epoch, that is era in the political life of the country, it has revealed many lacunae. Lacunae means there are so many gaps in this kind of anti-defection law. Its operation and failed to prevent defection. Really, did we prevent defection? No. We have seen what happens. People are resigning and then fight the by-election. It could have been strong if anyone goes out of the party by resigning. They should be banned from fighting an election for another 10 years. Then it may help in really fighting the defection. Now what happens? We have seen in MP, few MLA of Congress resign and BJP form the government. Some member got disqualified, they will fight in the by-election or the next election. This is what happens. So it could have been strong if we make such any party, any member goes out of the party, he will not be able to become a member for another 10 years. It will become strong. But political party will never do it. It does not make a differentiation between dissent. So what happens? There is no one listening to dissents. There could be dissent. I am a member of a party but I do not like the decision, and I am appealing against it, or I am not voting in favor of this bill because I am against the bill, though my party passed it. So in case of dissent, it is not allowed, because you have to follow the whip of the party. If party is saying we brought this bill, vote in favor of this bill. So defection is not making any difference between dissent and defection. It curbs the legislator right to dissent. So you cannot dissent. You just follow whatever the law they brings. Just blindly vote them. Whether you agree or disagree, you cannot decide. This is how political party works in India. And we have seen Indian politicians are really not ethical. These are bunch of crooks or unethical persons. Lot of this. There are maybe few exceptions. Freedom of conscience. So this criticism is that it does not differentiate between dissent and defection, and there is no place for dissent. This clearly puts party bossism, like party is the boss. Party said vote in favor of this bill. Say what we say. You cannot say anything what we don't want you to say. Sanction of tyranny. So it becomes tyranny of the party in the name of party discipline. So in simple terms, it does not differentiate between dissent and defection, and party bosses is there, so defection law is not that much effective. Also, distinction between individual defection and group defection. If a single person says that I will resign from party A and join party B, it is not allowed. It is irrational. In other words, it's been on retail, like single MLA says or member of parliament MP says I will not follow your rules of the party, I disagree with this, he will be say you are disqualified if the party does not condone him within 15 days. But if 2/3 of the members says we do not agree with this party anymore, will merge with party B, then they are not part of defection, they remain a member because it is happening by merger. It does not provide the expulsion of legislator from his party activities outside legislature. It does not provide expulsion of legislator from party of his activities outside the legislature. So legislature के बाहर कुछ भी करे, it doesn't matter. There is a discrimination between independent members and the nominated members. What happens? There is a discrimination. If a independent member after winning a election seat without any party ticket says that I'll join party A or B, he become disqualified to be a member of the party. But if a nominated member joins within 6 months any political party, he remains a member of the house. So there is no logic behind it. He was independent before fighting election. So after fighting election, he may want to join a party. Allow him, but it is not allowing him. If a farmer joins a party, so this is what it said. It is vesting decision-making authority is presiding officer. Its vesting decision-making authority is presiding officer. So presiding officer is deciding whether a member is qualified or disqualified, but presiding officer already belongs to the majority party. So it is criticized on two grounds. Firstly, he may not exercise this duty impartial because he also a member of a party. How can you expect him to be impartial? Second, he may not be a legal expert, so how his decision is valid. So this is what the criticism is about, because presiding officer deciding a member is disqualified or not, and he is also not a legal expert, plus he is a member of a majority party. And the experience educate upon the cases. In fact, two speaker of the Lok Sabha, there is Ravi Ray in 1991, what he say, and Shivraj Patil in 1993, have themselves expressed what they express, that doubts on their suitability, how they can educate the cases of defection. So what happens? We have previously seen that the amendment happened in 2003, that is called 91st Amendment. So what happens in the 91st Amendment? Let's see. The reasons for 91st Amendment is that demand has been made from time to time certain quarters for strengthening, amending the anti-defection law in the 10th schedule on the ground of provision has not been able to achieve the desired goal. So 91st Amendment, why it is done? Because we have seen this law is not achieving the desired goal. So we have made some changes. So what are these changes? Let's see them. On the ground that it allows bulk defection while declaring individual defection is illegal, the provision of exemption from disqualification of case split is provided in the 10th schedule. So previously there was a split. In 91st Amendment we removed the split. It is particular can undermine severe criticism on the account of destabilizing. So what happens in the split? If 1/3 member says we are not member of a party, we don't want to be this party, so this can bring down governments. So this is why split was removed. This split was like, if 1/3 member says we will not be a member of this party A, we'll do whatever we want. So this was very destabilizing split. So it is removed. Second is the committee. The Committee of Electoral Reforms. What is this committee? It is Dinesh Goswami Committee. It reports in 1990. The Law Commission of India in 170th report, Reforms of Electoral Law, 1990, and National Commission for Review of Working of the Constitution, that is NCRWC, in its report 2002, have inter alia recommended omission of the provision of 10th schedule pertaining to disqualification in case of split. The split option was removed because it could destabilize any government anytime. NCRWC also in the view that defector should be penalized for this action, debarring him from holding public office as a minister. If somebody is disqualified, is a defector, he should not be allowed to hold any public office or any other remunerative political post at least duration of the remaining term of the existing legislature or until the fresh elections, whichever is earlier. NCRWC also observed that abnormally large council of ministers like are being constituted by various governments. What happens? To keep the interest of all this merger and acquisitions of the parties and split, large number of ministers, there are 100 members and 50 ministers. This is very chaotic. So in this, what they say is that they have prohibited by law a ceiling on the number of ministers in a state. Like they put a limit how many members can become a minister in the state. If too many parties are joining hands, merger, split, we have seen a lot of ministers. So they put a limit, like they fixed to be 10% of the total strength of the legislature. 10%. This is their opinion, but we'll see what happens. So in the 91st Amendment 2003, they have made the following, that they limit the size. It is in the 52nd Amendment and in the 91st Amendment done in 2003, they put a limit or size in the Council of Ministers to debar the defectors holding any public office, to strengthen the anti-defection law. So if anybody is defected from the party, he cannot hold any office of the government or office of profit in anywhere in the India, whether state government or central government. Total number of ministers, including the prime minister, in the central government central ministers should not exceed 15% of the total strength of the Lok Sabha. So how many members are there in the Lok Sabha? You know this, it is 545. So he said that only 15% will become minister. Okay, so approximately comes maybe 82. So it said that you cannot have in the central minister, you cannot have more than 15% of the total strength of the Lok Sabha. A member of either house of the parliament, we know Rajya Sabha and Lok Sabha, belonging to any political party who is disqualified on the grounds of defection shall be disqualified to be appointed as a minister. If anybody is disqualified, the ground of defection, she was disqualified to be appointed as a minister. And the total number of ministers, including the chief minister in the state council or council of ministers in the state, shall not exceed 15% of the total strength. So 15% in the central government and 15% in the state government. There is only 15% of member can become minister. That means we'll put a limit on the number of ministers we have. But there is also another option, another criteria. The number of ministers, including the chief minister in the state, shall not be less than 12. So he's saying that maximum is 15%, but should not be less than, at least we should have 12 ministers in the state. A member of either house of the state legislature belonging to any political party who is disqualified on the ground of defection, also be disqualified to be appointed as a minister. So if anybody is disqualified on the ground of defection, he cannot become a minister, both in the center and the state. A member of either house of the parliament or either house of the state legislature belonging to any political party who is disqualified on the ground of defection shall also be disqualified to hold any remunerative political post. The expression of remunerative political post means, what is remunerative post? Remunerative post means any officer under the central government or state government where salary is paid. These are called remunerative posts. So if any member is defected, he cannot hold any remunerative post in any where in India, whether state or central. Next is any officer under a body, where incorporated or not, which is wholly or partially owned by central government or state government, and the salary of remuneration of such office is paid by the body, except where the salary or remuneration is paid compensatory in nature. What it's saying? He cannot hold any office of profit, in short. This provision of 10th schedule anti-defection law pertaining to exemption from disqualification in case of split one-third members. So it's saying that in the 91st amendment 2003 we removed the split option. If one-third member says we will not remain the party member of party A, that means they already defected. That means they are already disqualified and has been deleted. So this split option was there previously and it was deleted in the 91st amendment. It means that defectors have no more protection on the grounds of split. If any member is splitting, they will not remain protected or they will not remain member of the house. So that's all, guys. If you like this video, please subscribe. The next time we'll make some more videos useful for UPSC aspirants. Thank you.